So histories of citizenship education in late Victorian and Edwardian Britain argue that school pupils were taught to respect the law by learning about the legislative and judicial systems. A key aim of civics lessons, introduced piecemeal from the 1880s, was to teach working class children to become law-abiding adults. However, beyond the content of school textbooks, we know little about how this worked in practice. In this paper, I want to suggest that mock trials provided a new method for teaching secondary and a handful of elementary school pupils about the law at the turn of the 20th century. This shines new light on the school as an overlooked setting for legal education, beyond but appropriating the pedagogies of the law school. These diverse youthful performances held legal instruction and entertainment in tension. In this embodied activity, schoolboys, and less frequently girls, played the roles of judges, lawyers, defendant, witnesses, and jury. Some pupils gave deferential performances of adult judicial institutions. Others used the formality of the legal process to settle imagined school disputes, satirize issues of the day, and critique or reinforce gender inequality. The handful of girls' school mock trials I've identified challenged women's exclusion from the legal profession and jury service, barriers which were only removed by the Sex Disqualification Removal Act of 1919. We know a lot about other outlets for legal expression in popular culture in this period. Crime and courtroom drama was proving its entertainment value in novels, penny dreadfuls, music hall skits, periodicals, and newspaper columns. We need to place mock trials back into this story of how popular knowledge about the law was developed and contested at the turn of the 20th century. Mock trials show how the school had a role in socialising young people into legal language, principles, and process. This school activity has important implications for our understanding of the place of the law in modern British popular culture. As historians like Stephen Banks have shown, the mock trial has a long history as a ritual of popular justice and form of rural protest, which endured in small towns and villages into the mid-19th century. The mock trial then gets a new lease of life towards the end of the 19th century, in the music hall and in dramatic performances organised by law student societies. Teachers' magazines suggest 3 ways that elementary, primary school pupils could participate in mock trials: school entertainments, citizenship lessons, and debates. In 1895, the Teacher's Aid printed a dialogue for a school entertainment set in a magistrate's court. Pupils played the roles of 3 magistrates: a clerk, policeman, the prosecutor, and defendants. These were 4 boys who'd been found guilty of animal cruelty for torturing a cat. Dialogues like this one were a frequent feature of the Teacher's Aid. This example encouraged teachers to familiarise their young actors and audience with the setting of the police court. As Sasha Auerbach has recently demonstrated, this was the judicial institution that intersected most closely with the everyday life of local communities in this period. Arguably, the dialogue also served a moralising purpose. It was designed to deter young boys from similar behaviour. The following decade, magazines began to advise teachers to give their pupils more autonomy in directing mock trial proceedings. One teacher contributor to the Schoolmistress in 1908 described a successful citizenship lesson on justice. After reading about a trial for theft, the pupils recreated the scene. The mock trial was also recommended as a variation on the classroom debate. Writing to the Women Teachers World in 1912, one teacher recommended, quote, occasionally turning the classroom into a court of justice and substituting a trial for the usual formal debate. There are obvious parallels between debating and acting out a trial. Both gave pupils the opportunity to think on their feet, develop public speaking, and to follow formulaic procedure. In secondary schools, most mock trials were organised by extracurricular debating societies. At middle-class boys' schools like Manchester Grammar School and Bolton School, mock trials were regular fixtures, first held in 1894 and 1902, respectively. By contrast, schoolgirls' forays into judicial procedure were one-offs. The Debating Society at Bristol's Redland High School experimented with the format in 1891. Bolton High School's Poetry Club followed suit in 1915. 2 years earlier, fifth formers at Central Foundation Girls' School in East London had taken part in a mock trial in their civics lesson. This gender disparity in part reflected the more prolific nature of debating in boys' schools. However, the bar on women's entry to the legal profession, only lifted in 1919, was arguably more influential. Schoolboys' mock trials could be framed as potential career preparation in a way that their female counterparts' judicial endeavours could not. School pupils recreated courtrooms with considerable attention to detail. Trials tended to follow a similar format. They were mostly criminal cases tried by a jury. After opening cases for the prosecution and defence had been heard, the court clerk swore in witnesses for cross-examination. The judge then summed up, the jury retired to consider their verdict, and sentencing followed. This meticulous reenactment of courtroom activity demonstrates adolescents' familiarity with the legal process. For those less well-versed, taking part could be a valuable learning opportunity. The seriousness of the process served to heighten the comedic effect of the more farcical content of the cases, which I'll go into in the second part of the paper. No matter how irreverent the subject matter, the judicial process was almost always beyond reproach. The judge was treated with respect. The decision of the jury was final. Just as some teachers were eager to participate in school debates, they could also take on roles in the imagined courtroom. Teacher involvement was greatest at Redland High School, where women teachers played several leading characters: the judge, counsel for the prosecution, junior counsel for the defence, and one of the witnesses. Decades before the legal profession and jury service opened to women, school mock trials could provide a unique experience for female teachers as well as their pupils. Across all the schools, typically a teacher presided over the courtroom as judge. Translating the authority of the teacher onto the most senior figure in the judicial process reinforced a sense of reverence for the law. I'm now going to consider what we can learn from the content of school mock trials. On this slide, I've categorised 19 mock trial reports by case type, and where it's known, I've also included the verdict and the sentence. As you can see, a small number of cases recreated the sorts of crimes commonly tried in courtrooms: assault, bribery, corruption, and animal cruelty. This last case hints at the largest category in the table, school misdemeanours. It was a teacher's cat that the schoolgirl was accused of harming. 9 schoolboy cases about fictional incidents at Manchester Grammar and Bolton schools developed this theme. Crimes against the debating society were the most popular choice. 4 cases rooting out fraud and slander reflect the high esteem in which pupils held these institutions. Other cases included theft, damage to school property, and even an assault on a school cook. Here, schoolboys deployed the weight of judicial authority to tackle imagined grievances on their own turf. Perhaps school matters were easier subjects for improvised public speaking. Certainly, the opportunity to imagine outlandish scenarios within the school walls would have entertained the audience. When it came to sentencing, some judges were more lenient than others. In 1904, Bolton Schools Court took the crime of embezzlement of debating society funds extremely seriously. The judge, teacher Mr. Jones, handed down a sentence of 5 years in prison. At Manchester Grammar, sentences sometimes referenced school life. Prefect duty of the rowdiest corridor at the school was thought to be a worthy punishment for stealing refreshments. Meanwhile, the schoolboy who neglected to pay for his lunch received a somewhat kinder sentence of an enforced purchase at the school's tuck shop. I want to look now at 2 cases in a bit more detail to consider how pupils used the mock trial to satirise the gender order and current events. The earliest secondary school case that I've identified is from a girls' school, Redland High School in Bristol, which opened in 1882 and launched its debating society in 1890. The society was quick to experiment with its formats. It ran a mock trial the following year. In this case, the prisoner was accused of, quote, studying at a university subjects fitted only for the mind of man, and thereby departing from the ideal of womanhood. The school magazine report leaves us in no doubt as to the attitude of the schoolgirl and teacher performers. Teacher Miss Phillips argued her case for the prosecution humorously. However, the verdict of the schoolgirl jury was, quote, unexpected. The prisoner was found guilty. Perhaps following the process through to sentencing appealed to the jurors, or the girls wanted to highlight the stigma attached to the figure of the blue stocking. which they'd perhaps already encountered as high school girls, and they would certainly be further exposed to if they aspired to higher education. The sentence matched the crime, as judge teacher Miss Hatfield condemned the prisoner to 3 years in a residential school for instruction in domestic industries. Although the barriers to women's entry to the legal profession would have been well known, these aren't addressed in the school magazine report directly. The women teachers and girls appear to play the roles of judge and counsel without hesitation. This suggests their desire to show that a female-led court can operate just as efficiently as one run by men. As Wren Peppertone argued in their article on how women navigated entry to the Inns of Court after 1919, female barristers deliberately de-emphasised their gender to increase their chance of acceptance in these homosocial sites. It's interesting that the schoolgirls address higher education, not their own. Did they believe the fight for girls' schooling had already been won? Was questioning their own educational status too risky? Might the case help boost the school's reputation in actually inspiring more students to aim for university? What is clear is that the Redland High School's mock trial enabled girls and their teachers to participate in the vigorous contemporary debate about women's educational rights. The format in which they did so demonstrates in no uncertain terms their willingness to disrupt the gender order. In 1907, Manchester Grammar School's Junior Debating Society chose another topical subject for their mock trial, the militant suffrage campaign. This was only a year after a change in tactics led to increased arrests for the Women's Social and Political Union. In this imagined trial, 2 suffragettes, schoolboys Redfern and Broderick, were charged with assaulting the police. This shows that middle-class schoolboys were eager to engage with the legal dramas and political controversies of the day. The schoolboys emphasised the suffragettes' disrespect for authority. A policeman testified that the suffragettes, quote, cheeked him when he tried to arrest them and winked when he got them into the cells. This subversion of masculine political power mirrors the representation of the suffragettes in the press. Unruly, unsexed, yet hypersexualised, female protesters were presented as the perpetrators of assault. In reality, we know that suffragettes were much more likely to be victims of sexual violence at the hands of the police. The schoolboy suffragettes disrupt the courtroom process, and they are eventually removed. This was one tactic used by suffragette defendants. The 10 women tried for breach of the peace in October 1906, for example, had to be forcibly removed from court. To conclude, mock trials demonstrate how pupils used imitation and performance to engage with public life in a forum that delicately balanced instruction and entertainment. They're valuable examples of the role of embodiment in education, and they show early moves towards child-centred pedagogy at the turn of the 20th century. The content of cases was deliberately tongue-in-cheek, but courtroom proceedings were mimicked carefully, and for the most part with respect. Mock trials offered their participants and audiences an education in the judicial process and insight into the duties of lawyers, judges, witnesses, and juries. At the same time, they provided light relief from the more rigorous demands of school study. For aspiring schoolboy lawyers, this was useful professional experience. In girls' schools, mock trials challenged women's barring from the legal profession. Ultimately, school mock trials broaden our understanding of how people developed legal knowledge at the turn of the 20th century. Young people who were lucky enough to avoid real-life encounters with the judicial process seemed to jump at the opportunity to recreate the courtrooms of their civics readers or the more salacious accounts of newspapers and periodicals in their own imaginative performances.